Hi, I'm Marshall Cohen from Antonini Cohen Immigration Law Group. Today I want to speak with you about filing a visa petition or adjustment of status application for your parent. Now, if you're a U.S. citizen, your parent is considered an immediate relative under the immigration law. That means they're not subject to any numerical limitations. If your parent was paroled or lawfully admitted into the United States with a visa, you can file for their permanent resident status here and they do not need to leave. You'd file the visa petition, the Form I-130, and the application for permanent resident status, the Form I-485, with several other applications and supporting documentation and evidence here in the United States with USCIS. Hopefully USCIS will grant the applications and then your parent will be a lawful permanent resident. They will receive the green card several weeks after their applications are granted. Now, if your parent is outside the United States, you have to split the process. This is called filing the visa petition and then consular processing. So the first step, filing the visa petition, is you're filing the Form I-130 with other forms and documentation and evidence to prove the relationship. Once USCIS grants that, then the case is transferred from USCIS to the National Visa Center of the U.S. State Department. They will contact you to pay processing fees and the visa fee, and then your parent will receive an appointment at the U.S. consulate in their country. They will undergo a physical exam and also present a criminal history record, be interviewed at the consulate, and then hopefully the visa will be granted. Once the immigrant visa is granted, they'll come to the U.S. and they'll be lawfully admitted as a permanent resident and receive their green card a few weeks later. Please know that the green card is just physical evidence of the status of lawful permanent residence. So if you're contemplating filing for your parent, please give us a call. At Antonini Cohen, we know how.